Hello, I'm John Clarke, personal injury attorney in Fort Lauderdale, Florida. And I'd like to talk to you today about negligent security cases. Unfortunately, in a big city like Fort Lauderdale, crime is a fact of life. Even when you take reasonable precautions, you can become the victim of a crime when you're just going about your daily business. Have you ever wondered if you are mugged in the parking lot of the shopping mall, for example, who's financially responsible for your losses? Well, the easy answer is that the criminal is, right? And very often the police and the state attorney prosecute criminals, and depending on the circumstances, they put them in jail or they fine them. But these punishments don't do anything to make you, the victim of the crime, financially whole. Well, what else could you do to try to recover for your losses? Well, you could sue the criminal in civil court for battery or conversion. And if you prove your case, you could get a judgment against him. But this is often not possible or not practical, because often it's the case that the criminal runs away and remains at large, so you don't even know who committed the crime. And if the criminal is caught, it's often the case that he doesn't have the assets to pay a judgment. So filing a civil lawsuit would just be a waste of your time. But there is one other option, legal option for you to recover for your injuries when you are the guest on someone else's property. And this is a negligent security case. Now, negligent security cases can involve robbery, rape, or a slip and fall that was caused by an unsafe physical condition. For example, a pothole in the parking lot. So let's look at what the elements are that you, as the victim of a negligent security incident, would have to prove to win your case. Well, first you have to show that you were the guest on someone else's property. And if you were, for example, shopping at a store during regular business hours, then this condition would be satisfied. Next, you have to show that the owner of the property had a duty to take certain security measures to protect you, then that the owner failed in their duty to protect you, and as a result of that failure, you suffered your injury. So let's look at a real-world example to better understand how the elements of a negligent security case work. So supposing you go to your local convenience store, and when you enter the store, a robbery is in progress. A masked gunman has pointed a gun at the cashier, and the cashier is handing him money from the register. Your entry into the store startles the gunman, and he orders you to get on the floor. However, you panic, you turn around, you try to run out of the store, but the gunman fires a bullet that hits your leg. So as a result, your leg is broken, you have a complicated surgery and a long recovery. So you want to sue the convenience store for negligent security. Well, what specifically do you have to show? Well, first you have to show that you were a guest on the property, which is easy, again, because you were shopping there during regular business hours while the store was open. Secondly, you have to show that the owner had to have certain security measures in place to protect you, and that he did not, in fact, have those measures in place. Well, what measures would be reasonable for a convenience store to adopt to prevent crime? Well, the Florida legislature passed a statute that mandates convenience stores have certain security measures, presumably because convenience stores historically are high crime establishments. So this statute, which is 812.173, requires a convenience store to have a video surveillance system, lighted parking lot at night, a safe for the cashier to deposit cash, as well as a window that provides a clear view to someone from outside the store of the cash register. So if you could show that the convenience store where you were injured did not, for example, have a video surveillance system, this would be very good evidence for negligent security. And keep in mind that the measures that the statute mandates are just the minimum. You know, if the store where you were injured happened to be in a high crime area, and let's say it was robbed last week, then it might be reasonable for the store to employ a security guard or have 2 employees on duty at any given time. So what else do you have to prove to win your case? Well, you have to prove your damages. So you have to prove that your leg, in fact, was broken, what it cost to have the surgery to fix it. And you have to prove that the bullet from the gunman's gun actually caused your broken leg. And you should be able to prove these elements pretty easily with medical records, testimony, and possibly video surveillance. So in summary, if you are the guest on someone else's property in Florida and you get injured, you may be able to recover from your injuries by suing the owner for negligent security. If you believe you have been injured by someone else's negligence, please give me, John Clarke, a phone call at 954-556-8952 for a free consultation. If you enjoyed this video, please like it. Have a great day, and I will see you in the next video.